Welcome back to Sun, Sand, and Sold. We're here with David Podein from Haber Law. David, welcome to the show. Nice to see you.
Thank you so much for having me. I think I was your first subscriber, and now I'm here in the studio.
Was that forced subscription? Was that like did David walk in your office and say, you have to sign up for my podcast?
No, I'm number one.
All right, he's a true number one fan.
I'm trying to get my wife to subscribe.
that's the real trick. She's like, I hear enough of you all day, every day.
Let me tell you, getting Lisa to subscribe to listen to me.
I do not need to hear more of my husband's voice all day. And
oh my
all
God!
night.
I said, why don't you listen to it while you're walking across Venetian Causeway?
She's like, that's the one time I'm getting away from you.
I think I'd rather run in traffic.
I think she'd rather dive off the Venetian Causeway than have to listen to an hour and a half of you talking. Well, David, welcome, and obviously, for disclosure, obviously you're a part of Haber Law. You're a partner at Haber Law, and you've been specializing in condominium for a while.
I have been. I've worked at Haber Law for 15 years now.
Ooh, goodness!
Sort of.
He saw Haber
parts of the
Haber 1.0.
Yeah,
Haber 1.0.
Been there for 15 years now. We handle all aspects of condominium association representation. We focus on high-rise, high-end luxury buildings. Within the condo practice, I focus a lot on capital improvement projects, board governance, special projects, and things like that. And then over the last 10 years, I've really expanded my real estate practice as well. High-end residential, purchase and sales, commercial real estate transactions as well. And we're kind of at a crossroads now where there's a lot going on in the condo market, a lot going on in the real estate market, and they're kind of converging, be it condo terminations and other interesting transactions here in South Florida.
Right. I think it's one of the interesting things about the industry, and we've touched on it in earlier episodes, but I think we're going to talk about it more as we go forward, which is that convergence. It seems to me like the difference between asset types, the difference between transaction types are getting closer and closer, and you find out you're working in one area of real estate and you may as well be working in another area because they all wind up kind of being in the same pool. It's very interesting. Obviously, it's a great segue talking about your work in high-rise and high-rise condo and talking about branded condos. And we opened the show and sort of had a broad, sometimes meandering conversation about branding here in South Florida, its meaning to us, why South Florida is sort of brand obsessed, and what some of the layperson pitfalls are in terms of branded residence and sort of where that's going. But this really all stemmed from you and Max Haber doing a really interesting op-ed in the Miami Herald that was about branded condos. What was the genesis of that? How did you guys end up deciding to write about that?
Well, we try to be market observers. We participate in the market and representing clients, but we try to be a market observer and see what's going on, what are the trends, and then how can I comment on that, or how can I give my perspective of, hey, this is something that's going on, but no one's talking about X.
Right.
So with respect to the branded buildings, I felt like you had splashy headlines, New York Times, Wall Street Journal, but no one was really saying, like, what are people buying? What are they getting? And obviously, as lawyers, we dug into the contracts and to say, like, this is what's actually going on the piece of paper that governs that brand, that license relationship.
Right.
So what did you find in looking into these license agreements or branding agreements?
I would say the big takeaway from it is, I think if you ask someone who's buying a $5-10 million residence at a high-end branded building,
like the Porsche Tower or Aston Martin, or
sure, they think like that brand is permanently attached to the building and that they own that brand for the purposes of the building is there forever. And the big takeaway is that's not the case. You look at these agreements and there's all kinds of outs for the brand holder, the licensor, in terms of if they don't like the quality of the building or the operations, or if they're not still tied in with the management in some aspects. So we really wanted to show some of the behind the scenes things in terms of what's going on, what are you actually buying, and what you should be mindful of.
Well, let's back up a minute here. So when you're buying a branded residence, what does a branded residence actually mean? What's the sort of the high level practical reality of buying a branded residence? So if I'm buying the Josh Tomey condo in the Josh Tomey Tower, what does that really mean to me?
Well, for me, it means don't buy.
Better have a good gym.
I would buy.
You can ignore the seat to my right. But seriously,
better have a good gym if Josh is there and healthy food.
What does it actually mean?
So the Josh Tomey brand, you own the brand, you own the license, you've licensed.
Who's owned? The condo association.
Let's just go with your example, the Josh Tomey brand. You would license your brand, your IP to a real estate developer.
IP is intellectual property.
Intellectual property. You would license your brand to the developer. And you'd say, hey, this brand is so valuable. It's into wellness, it's into business, it's into fitness. That's my brand. That's the buyers it's going to attract. That's the value it's going to bring to the table. You're going to pump up your price per square foot by X by attaching the Josh Tomei brand to your building. So the developer is going to enter into a license agreement with you, probably negotiate that, you'll get some points per sales and say, hey, on the price per square foot on these sales, we get certain points. And depending on what kind of brand it is, sometimes with the hotels, they then tie it in with a management agreement as well, where they get compensated and say, hey, to use the brand, you also have to use our management services.
Right.
So the brand is really just a licensing arrangement with a real estate developer. And then you still have what you would expect to see: a traditional real estate developer buys the land, gets financing, gets a capital stack, hires a GC, and then builds the building. But now they hold those rights from your brand.
But only for a set period of time.
Yeah, so that's one of the other big takeaways from the article is these are, like I said, they're not recorded against the building. It's not a true ownership of that IP by the unit owners in a collective way. These license agreements, they have term limits. Some of them are 10, 20 years. But even more concerning than the term limit is if you have problems with the buildings, if you have major construction defects or operational issues, the licensor, the owner of that brand, in a lot of instances, obviously they're all slightly different. These are individualized contracts that are negotiated. But an overarching theme is that the licensor, the holder of that brand, can pull their brand off the building. If you're not maintaining it, you're not maintaining, and a lot of times these are vague standards.
Right. And is there any standard? I mean, is there any legal sort of precedent or orientation that you have to go into with these license agreements? I mean, how are they actually executed?
Purely negotiation within the four corners of the documents, what the parties agreed to.
Now, the buyers are privy to this. I'm assuming that these are integrated into some of the initial filings of the condominium so that a potential buyer is going to be able to see some sort of transparency around the license agreement, its duration, its actual meaning, execution.
Do they get to see the license agreement or know what its basic terms are for length of the license?
It should be included with the governing documents, which are disclosed. But what I find is, regardless of what you provide in those disclosures, most people are not reading them. And This goes back to another prior article that I wrote a while ago called Digging Deeper Before You Buy a Luxury Condominium. If you were going to buy a business, you'd want to see the company's operating agreement. You'd want to see the budget. You'd want to do all this due diligence. You might even hire a third party to help you evaluate and do all these different things. And that could be, you're spending $1, $2, $5 million. But people buy into a business, a condominium association. It's a not-for-profit, but you're sort of going into business with all these other people. But I find people aren't reading. They're not doing that due diligence. They're not really hiring third parties to do it for them, whether they're attorney or the realtors or things like that. So yes, it's in there, but who's really reading the governing documents and the disclosures before they purchase?
It's one of the things we had talked about previously on one of the prior shows about with the passage of the new laws in Florida. You really want to know what's in those engineering reports now. You want to know what's in the financial statements, and you want to know how much, whether they've waived reserves for the last 30 years, or whether they actually have some money there to do some of the repairs that are going to be needed. So what you're saying is, if I understand you correctly, you want to do some due diligence when you're buying into a new condo about the branding and about what you're getting.
Certainly. I mean, if you're buying in a certain building because that name means so much to you and you're placing such a value on it, it's essential to your decision to buy in that building, I think you should know what rights you're actually getting as a unit owner.
Yeah. So one of the things we talked about before you got here was the value of the brand. And shout out to Jeff Frett and his father. They're big Corvette people. And they've had Corvettes their whole life. They love Corvettes. And so if there was a Corvette building, I could see them buying into the Corvette building. Or someone, my cousin Dan is a big Porsche guy, so he might associate with the brand Porsche. So one of the things I had mentioned earlier was, given the brand status in sports and in hotels and in condos now in South Florida, maybe there are other benefits that they can give or would give, such as access to Formula One tickets or access to tennis or golf or other sporting events that they're sponsors of. Or if it's a watch brand, being able to get, or even a car brand, being able to get
limited releases,
special release products that you can't otherwise get that are highly sought after.
Let me turn that into a question. Do you see special incentives alongside the branding that are meaningful to a buyer?
I have not. I think there's opportunity for that. I think that's a really interesting avenue because, really you're sort of creating an ultra VIP community. You want to tap into the consumer, your buyers need to feel special, get special treatment. And it ties in with, car collectors, watch collectors. The whole name of the game now is limited releases, special releases, and having access. So if buying into the real estate is a way to make that community and give them access, I think that's something that, you could see come down the line.
But not something that you've seen specifically.
No, from time to time you see, particularly with the car branded buildings, sometimes with larger units, penthouse units, they're including special cars, but I don't think they're really taking it to that next level like David Haber's suggesting, where you're really getting attached to the brand and being a VIP in that community that you so much identify with and want to identify with.
I think that's a potential future expansion of the use of brands. Josh brought up a point before the break about the Mercedes, what's the name?
Mercedes-Benz Places.
And he talked about that it's more, I don't want to say middle market, but it's not the uber wealthy. And as you know, Mercedes used to be an uber wealthy car brand that decided to break into middle market cars where they're selling cars for $40,000, $50,000, $60,000 instead of, when they used to be ultra luxury only. And so do you see these brands going into a middle market, and do you see other companies trying to hit that middle market with branding?
I do. I think that the middle market is going to expand. You only have so many elite luxury global brands that your 0.001% of consumers want to identify with.
Right.
There's just a finite amount. Many of them are very old companies that have been around for a long time. There's a reason for that. It's hard to create a global superpower luxury brand. And it seems like these buildings in general are selling well. So you're going to have, I don't want to call them copycats, but you're going to have the market expand more because we only have so many uber brands. So I think if the market, demands it, you're going to start bleeding into this middle sort of market of brands. But I think those buildings are not, if I had to guess and I had a crystal ball, I'm not sure those buildings are going to perform as well. I think the branded concept hits really well at a high end where you get that sort of emotional consumer attachment that it's special and you're a part of something. And I just don't think consumers and buyers necessarily feel that for kind of middle market brands.
Right. And that association, again, we talked about before the break, we talked about, like you said, that emotional association, that sense of this is representative of my lifestyle and who I am as a person and sort of the badge I wear, like car ownership.
Yeah. And I think it's important to point out that from what I've read and what I've seen is it has a very strong resonance with international buyers.
Oh,
you
agree
already
with
have
that.
International buyers that already feel relatively safe, for lack of a better term, parking money in condominiums in Miami, particularly new construction condominiums. And then if you're attaching a global brand to this that identifies with this crowd, it sort of accelerates, I think, that buyer demand because you already have people looking, hey, I want to invest in real estate in America. Am I going to do New York? Maybe not. Am I going to do California? Probably not. I'm going to do it in Miami. And then looking at where in Miami, maybe in these branded buildings, I think it attracts more of this global wealthy buyer crowd.
You think it gives them a sense of security?
I think so. I mean,
as well as the emotional?
Maybe a false sense of security.
I'm definitely not part of the global wealthy buyer class, but if I had to guess, I think that is definitely a trend that's going on. Developers see it and they're capitalizing it because these buildings are selling very well.
Right.
So now let's talk about when the brand crashes.
Or maybe not just a crash, but what happens when there is a pivot in terms of brand perception. Before the break, we talked about Trump and some of the labels that buildings carry with Trump, and again, not to talk politically, but more to say, we know we're living in a highly political world here in the United States. We know that there's a lot of division, and obviously we know that there are cases with Trump assets, or at least Trump branded assets, where there have been issues in terms of whether to keep the name, or even in some cases stripping the name as a result of certain actions, whether it's what's gone up in New York or otherwise.
Yeah, and I would even expand it sort of beyond politics and say it's like the consumer is fickle, like the zeitgeist is fickle. Like someone could, a brand, a person
Zeitgeist.
associated
Oh my God.
with a brand can be sort of canceled very quickly. Look at how quickly sort of people turned on Kanye West.
Right.
Well,
Because
that's
of
a
all
good
his
one.
controversies. He had a billion
Well,
dollar,
and Yeezy on the shoes.
he had
right?
a
Right.
billion dollar brand with Adidas.
Mm-hmm.
And,
Good point.
The consumer turned on that very quickly. And I think we brought that up in the article of if you had a Yeezy branded building, which when you look at the brands they're using, doesn't sound crazy if someone would have came up with a Yeezy branded building a couple years
It
ago.
wouldn't have shocked me.
But look how quickly that's turned and how quickly a name, a person, a brand can turn toxic. So I think it's even more than just politics. It's sort of can come at from any angle. And so, I think you're going to see that happen. I don't know what brand it's going to happen with, but we can assume that, it's probably going to happen with some brand at some point, as it has with ones in the past. And you're going to see the condo association call up the lawyer and say, how do I get out of this?
Well, how would they get out of it? I mean, let's start talking a little granular. What are the, you talked in your article about rights and restrictions, and again, some of the risks that come along with this type of purchase. What could a condo association do? And let's assume that the units have all been sold. They've turned over administratively. So Kyle, when a condo sells either a certain number of units or the totality of its units, statutorily, you have to turn the control of the association over to its residents at a certain point. And so let's assume that's happened, David. What rights, and obviously I realize it's license dependent, but on the whole, what rights could you see a condo association having?
So hopefully the agreement has some teeth as to reputation and sort of how the brand is perceived, that you could hang your hat on and say, hey, there's been these material issues where the brand is no longer perceived as what we contracted for. So I would hope that, you have to look at the agreement and see, is there something we can hang our hat on that because of this public turn of events, it's now viewed in an unfavorable light. This is not the brand we contracted for. Other than that, you might want to get creative in terms of, if you're no longer going to use the management company, or if there's any other parts where you can say, hey, we're done, we need to walk away. The other part of it is people don't always want to hear this, but you can also, get aggressive with it and maybe just say, hey, we're going to terminate, and sort of dare them to sue you, particularly if it's a brand that's dwindling down. They might be eventually shutting down because they're getting canceled. Like, are they going to really pursue the building? It's not, most of these, there's not like a huge licensing stream on the back end.
Right.
So it's like, are they really going to get into a big litigation?
They got the first
with you?
big check already.
They
and so
already
it's
have
like,
been
right.
paid for the most part.
Right.
So we talked earlier about things like Joe Robbie Stadium that has been renamed 5 times. We talked about
Which is your favorite?
We talked
which
about
is your
Cas-
favorite?
He still calls it
Joe Robbie Stadium. The man built it. That's it. He deserves the name.
We talked about Kaseya Center and its predecessor FTX
Yeah.
naming, and how quickly that sign got stripped off that.
But one
arena.
thing we haven't talked about yet is office buildings. We haven't talked about commercial and office buildings. It's not just condos. I remember, again, you weren't here, when the tallest building in Miami was the Southeast Bank.
Financial Center, right?
The Southeast Bank Financial Center, the tall white building with the big atrium. And that was the tallest building in Miami. And then Southeast Bank went out of business,
Right.
and was taken over by the RTC. Or the Centrust building, which is the Cake Tower building,
Right.
where David Paul went to jail for numerous nefarious activities, went to federal prison, I think. And Centrust, I believe, was taken over. So, there was a lot of really name recognition with being in the Southeast Bank Financial Center or being in the Centrust Tower. And we did talk about the Chrysler building in New York, but there is a status to being a lawyer or an accounting firm, a law firm, an accounting firm, a financial private equity firm, being in one of these, if you will, named buildings.
Well, let me
Like whether it was World Trade Center, now One World Trade Center, there's a status associated with it. So what happens when, FTX is accused of $1 billion scam, or if Southeast Bank goes out of business, or any of these office type or commercial spaces has the same kind of issue that you talked about with Yeezy.
And building on that, to the question to you, David, is I presume that if it goes out of business, then all up for grabs in terms of being able to pull out of a license to the extent that you just said in your last answer. But maybe what if the licensor at their election is trying to pull out? I mean, maybe there's an incident at the building that reflects poorly on the brand. What do you think the rights and obligations of the licensor are if they say either A, we want out, or B, at the end of a 10-year period, say, we're not going to renew, and now I've got this unbranded building?
I think you're going to see that happen. I think the licensors, generally speaking, have broad rights under these agreements to pull their name off the building if there's problems with the quality, maintenance, operations, incidents. A lot of the agreements I've seen have very broad language in favor of the licensor to pull it off. So I think you're going to see that. The contracts are set up that way to give them that latitude. So I think you will see that.
And what happens, and I'm sorry, Kyle, just one follow-up on that. What happens, because I think this probably is where the rubber meets the road in terms of, and I'm not going to hold you to a legal opinion here, but assuming generally what you know about these agreements holds, what rights would an association owner have in terms of proving a loss in value as a result of that? Because I assume that's probably where there is the most substantive potential for disagreement, is to say, you pulled this name off the building for one reason or another. I bought because it was this brand, and now it's no longer branded that way. I can't sell it for as much as I bought it for because it no longer has that brand cachet.
You got to hire me for that one.
All right, so that's going to
No, but in all seriousness, I think you're going to see it more that if this scenario happens, you're going to see unit owners point the finger at the management company or the board and say, you ran this building into the ground that resulted in us losing the brand deal. And so I don't see the unit owners going after the brand as much, because the brand will say, hey, I'm in privity with the association and I pulled it pursuant to Section 3 of the contract. I'm allowed to cancel because I no longer feel comfortable with what's going on in this building, or whatever vague language they have. But I think you could see unit owners go after their board of directors or their management company and say, you ran this building into the ground. You caused us to lose this brand deal, which is very valuable, and thus we've incurred damages because of your improper actions. Caused us to lose this deal, lose the branding rights, and lose money on the value of our units.
So my question with that in mind is that a person makes an investment and they buy whatever in a building based on the brand. The brand is tainted. They decided to leave. Something happens in the building. What does it mean for the investment of that owner? What is their monetary loss because of that situation?
And we want exactly dollars and cents.
Well, I mean, I think you've seen it. I mean, I think we had buildings that were branded with a former president, potential, could be upcoming president. And there was a time in the market where people were saying, like, we were taking losses because of the Trump brand. Whether that's true or not, like, I think people did make those claims. But
they took the brand name off the building on the west side for sure in New York.
But I doubt that's going to be an actionable claim that you could really pursue and prevail on, because I don't think most of these agreements have that much teeth that's going to inure to these unit owners to say, hey, you didn't uphold your brand because you messed up on X, Y, or Z, and thus I've suffered damages.
I can guarantee you, even though I haven't read these branding agreements, that they say something to the effect of there are no third-party beneficiaries, and you cannot get any incidental or consequential damages regarding the value of the units based upon our keeping or getting rid of. You would assume
that'd be the case. Although obviously anybody can sue anything.
Yeah, but I mean I tend to agree with David. If there was really a claim, it would be against the board. Now the boards have protection for the business judgment rule under Florida law, but if they are willful, wanton, intentional misconduct, but if they let the building literally, go to a tremendous state of disrepair, well, then they're going to get sued, like what happened, unfortunately, in the tragedy of Champlain Towers, where the board got sued. Now, I do want to, and I raise that for a very important point. There used to be a Champlain Towers North and a Champlain Towers South.
It's a great point.
And I think there was one in the middle. I don't remember. But they were all Champlain Towers. One of the things that occurred after the tragedy,
Very quietly,
they changed the names of the building to get Champlain Towers off the name. So, that's one issue of removing the brand. But now I have another thing. One of the reasons that they took the Trump name off that condo building on the west side of New York City in Manhattan was there were protests out in front of the building. So once you have a problem with the brand, what's the impact on the residents? And in that case, they had people out there day and night picketing and protesting in front of their building, and they didn't want it.
and maybe it's not just a value question, it's one of just basic logistics and saying, now I'm living in a building, whether I agree with the ethos behind the brand or not, I can't get into my garage because I got 40 protesters in front of the garage every day.
Or I'm walking in the front door and they're throwing paint or eggs at me because, it's kind of like PETA when they used to, people wearing fur and they used to throw paint or eggs on them.
Right.
So, depending on what the brand is and what it stands for, you could have these kinds of issues.
Right.
And then I have one other point I want to make, and that is we haven't seen it yet. But what about you mentioned the L building and whether it's going to be branded towards women or fashion or the like. What I would be really interested in seeing is if there's going to be an environmentally sensitive building and have it branded based upon its environmental sensibility and it being one of these energy efficient, really special state-of-the-art protecting the environment buildings, whether National Geographic or something like that
Right.
would ever, brand something like that. I think it would be really interesting.
That's cool.
Right. That is an interesting thought. And yeah, I mean, you could develop brands around political causes, around environmental causes, around any of that.
But that's the point. We have only been talking about them from perspective of retail, high-end commercial sales of high-end luxury brands. We haven't been talking, but it would be an interesting thought based on social causes or other types of issues that are important to the people who live there.
Well, let me build on that with David. And the question to you, David, is to David's point about saying, so that's sort of the actualization of a brand strategy. Are you seeing anything in these buildings? And I think you started to talk a little earlier. Are you seeing anything in these buildings that is more functionally relevant in terms of saying, when I'm buying into this, put the licensing agreement aside, put the value proposition aside of a brand. And you talked a little bit with David about, whether or not you got sort of benefits from the brand. Are you seeing other hallmarks or patterns in terms of what somebody's actually getting in a branded building that differentiates it from the rest of the market when the name is not of concern and the license is not of concern? How are these buildings different, or are they?
So I guess the answer is it depends. If you look at some of the primary examples with the desert buildings, they went all in, high-end luxury brand, and then they added that extra thing that ties in with the brand also at the building with the Deservator, which was very unique, automated.
The Deservator. I don't think I knew it was called that. That's the elevator,
Yeah,
the
so
Porsche design tower.
Yeah, the Porsche design tower and the upcoming Bentley tower will have the Deservator, which is an automated luxury car elevator that then drops the car off. So it's parked
in your
unit where you can
on
have
display.
your Porsche, Bentley, Bugatti, whatever, parked there. You can see it, you can enjoy it, you can open up the sliders and be with your million, $2 million.
Stare at your million and a half.
Be with your baby.
So I think that hit the nail right on the head with like what you're kind of talking to, where it ties in something special at the building with the brand, with luxury, with something no one else has.
But that's what they're doing with the cars, with that. What do you call it? The Delevator,
Deservator.
The Deservator.
Deservator. It'll be interesting to see if it's not car brands, how they can do branding. That elevator that he created was specifically designed to deal with car brands. So if it's going to be a Rolex brand, or if it's going to be Audemars Piguet, or if it's going to be...
Are we already seeing Armani, L? I mean,
Yeah,
Missoni.
David Haber mentioned it earlier. I think you'll see them tie in with where that brand fits in other commerce, sports, culture. What are they involved in? What are they sponsoring? That then you get to be a part of that. And then you're going to see hospitality, I think, get more and more involved in this branded space, because we have, a trend of private clubs, private hospitality experiences. I think those brands, you see Major Food Group getting involved in this space. You see private restaurants coming up at luxury buildings. I think there's going to be more of having private social experience, private club, private restaurant, and then tied in with kind of what David Haber suggested is what events and VIP access do you get that aligns with the brand and where they are in the market.
Right. And I'm glad you raised Major Food Group. We talked about MFG a little bit earlier. They're doing a really interesting project with Terra Group and 1000 Group and putting together a called the Villa Residences, which is a food and beverage centric condominium association.
Oh, for foodies.
It's for foodies, and it's going to have an anchor Major Food Group restaurant in it. There's going to be food and beverage.
So you're going to take me there for dinner because we're both foodies.
I will take you there for dinner. But again, it's a great example of a more granular delivery of
Mr.
something
Everyman?
associated with the brand.
Yeah, and I think you're going to start to see other entrants into this space where they, to my knowledge, were the first sort of hospitality brand to get in. And at least at first, tell me what you think. People kind of were like, getting in here. But, now that it's already in the market, I think it's going to become more of a normal concept, and you'll see other types of brands coming in. Like, it was already kind of crazy, like a car brand. Like, what does that have to do with a building?
It's lifestyle.
They kind of tied it in with the Deservator, but you have other buildings branded around cars where there's like no tie-in. So some people it doesn't click with, but I think you're going to have other entrants, hospitality, and other brands come in that are not as obvious, but then eventually the market will absorb it.
And we'll talk about hospitality now, because I think, one of the companies we raised earlier was Groot Hospitality, and talking about a David Grutman, a Pharrell, and obviously they went from restaurant branding into hotel branding. It seems I don't think any of us would be shocked to see a Groot Hospitality, centric building in the near future. But as far as what we have now, one of the subsets of this market is obviously hotel flagged residences. So that was probably the earliest iteration of all of this, and we saw this many years ago, where a Four Seasons or a Ritz-Carlton or a Mandarin Oriental, typically was high-end residences, but we've seen some middle market entrants as well, would develop a hotel, and in parallel to that hotel, develop a condominium association, sometimes within the same building, sometimes as an adjacent. My question to you is, on those, obviously there is the likely understanding that those residences could be also benefiting from those high-end hospitality services, whether it's the food and beverage or the staff at the hotel.
Or a spa service.
All of that.
I didn't mention it earlier, but what about Canyon Ranch on Miami Beach?
Right.
That it was all about the Canyon Ranch experience.
The wellness was the angle.
But in Carolina, we know that's a
they pulled out,
case.
and Canyon Ranch is no longer associated with that building.
Right. So back to the hotels then, Dave. What are you seeing the fundamental differences aside from the obvious in those kind of arrangements? Because obviously, those seem more stapled to services and management that really ties to that hotel flag.
Yeah. So you're seeing the management agreement tied in with the brand, and that they both need to be in place. And in order to keep the brand, you need to keep the flag there as being involved in the management. And then at these types of buildings, you're also seeing more complex issues because of the shared components and the mix of competing interests there. Because, we were talking a lot about classic high-rise branded luxury condominium buildings. For the most part, those classic examples are strictly residential condominium buildings that will sell out and they're turned over to the unit owners. But you have others, particularly with the hotel flags, where it's sort of a mixed development. You have residential condominium. You might have a hotel component that is part of this master association. You might have commercial unit owners, and you might have a whole sort of mess of competing interests at that building.
Right. And so my familiarity with that particular type of condo, and for Kyle's edification, that shared component reference that David made, the way a lot of these associations are designed is what might traditionally be common element to the condo association, like a lobby, the hallways, other amenities, are actually owned by a commercial parcel owner who usually is also tied backwards into the hotel flag in one way, shape, or form, whether it's contract or it's actually their brand. And so in those cases, David, then we see the competing interests that you're talking about are sort of saying the hotel and the owner may be driving a lot of expenses around that shared component back over to the condos. And I think there's been some issues there.
I was going to say, David, can you talk about why the hotel parcel owner wants to have control over the lobby, over the elevator lobbies, over the elevators, and what the purpose of having shared components rather than common elements is, and what the tension is?
Sure. So one of the reasons they want to have control is they want to maintain the standards. They want to maintain the quality. They want to maintain the look and feel of whatever it is. I mean, you can probably close your eyes and picture what a Four Seasons is going to look like. You can probably close your eyes and picture what a One Hotel is going to look like. And so you can imagine that these brands, where in this scenario, it's a little bit different than what we were breaking down before, where Josh Tomei licensed his brand and that's it. Now you have the brand is, the hotel is, they're still there. They have an ownership aspect of the building. So it's not just a brand, they're operating and owning part of the real property. So to David's point, they have a vested interest, and their argument is, hey, we're in a better position to maintain these shared components because we want to manage it properly. We want to keep it up to brand standards. We want to keep it in the same theme. We don't want to lose the image. We want to keep it consistent with that look, feel, and touch that presumably people are paying for.
And so where are the problems in that? Because it sounds totally reasonable. It makes all kinds of sense. You're buying into a branded hotel residence. Why would you not want that? Where are the problems?
Right.
Well, the problems is, it comes down to money and control. So it's who pays for what, how much they pay for what, how is it calculated, is it fair, what's the formula, and then the control of, who gets to say, who gets to vote on it. Because on the flip side of the coin, when you have a residential condominium component at one of these buildings, they're saying, hey, you can call these things whatever you want. Our argument is these are common elements. These are common elements of the building. We should control them. We're the unit owners. The hotel component's small. If you look at on a per head basis or per square foot basis, you're charging us way too much money. We're sharing the lion's head of it so you can artificially inflate your net operating income, and we're really subsidizing you. So we're getting the short end of the stick here. That's the two arguments. That's the tension. That's where you've got a number of lawsuits around and a recent bill to
Well, I know House Bill 1021 tried to provide some clarification and either support of that, and I also know that David was mentioning Canyon Ranch, which became Carillon. I mean, Carillon was certainly a precedent level case in terms of some of the enforcement actions that association tried to bring against its developer and commercial parcel owner, and obviously there was a lot of implications of that in the industry.
But besides the money component, and it always comes down to money, there's also the issue of who can make the decision.
Yeah, the control.
You got 100 or 200 unit owners, and in a regular condominium, trying to get them to agree on what a lobby should look like is, it's crazy.
Good luck.
Right. So typically you'll have a committee, and the committee will make a recommendation to the board. The board will put up a set
Everyone
of
loves
pictures.
committees, by the way. Committees are the bane of a lot of people's existence.
And then they'll show it to everybody, and then they'll say, which of the three do you like? And then they'll take like a straw vote, and then the board will decide. In a hotel condo, where one of the goals is to get the most dollars per night that you can get, the hotel owner, they're in the business of hoteling. They want everybody to be in their pool, if you will, for reservations and setting up, your condo hotel into the pool that they have created, whether it's Marriott, whether it's Four Seasons, whatever it is. They feel they know best how to market a hotel and how to keep up quality. An individual unit owner who may get assessed $5,000 for capital improvements is going to look at the lobby and say, it looks fine. What's the problem? Those couches are great. Whereas the hotel brand owner is saying, no, it's not. In order to keep up with Amman, we have to do X, Y, and Z. And the individual owner says, no, you don't. And now you have that tension. And part of it, again, comes down to money. And as David Podein said, it comes down to control.
Well, I was
Who's
going
in
to say,
charge?
are they disagreeing because they have a stylistic difference of opinion, or are they disagreeing because they feel like they're being, the weight of the dollars is unfairly burdened on the condo association, which I understand is often the case in these arguments, which is to say, it's not only aggregate sums of money, it's the way it's being assessed.
I think it's both, don't you?
It's both, and there's been some articles about it, and you can see the sides in their quotes, but I think it's both. They're saying that how it's being allocated on a dollar for dollar basis is unfair, and they're also on the condominium side, they're arguing you're stripping away too much of what we own and control, and that these should be common elements, and you've gone way beyond anything that is sort of hotel related, and like really you're just saying all these people own is this box and don't have any say at all over their common elements, or what they're arguing is common elements.
And what if the pool area used to have a tropical feel,
yeah,
and the brand decides they want a high-tech feel, and the owners go, we like that tropical feel, and the brand says, in order to keep up with the Joneses and the new 6-star resorts, we need high-tech
Right.
this and high-tech that.
And it's because it's not a common element. You don't have that material change, piece that you can support in the law that says we have to get an amendment to do it. And so you've got, you've got all these other issues. What I guess I would ask you, and I'm going to play devil's advocate on behalf of a developer, is to say, but all of this was disclosed up front. The method, the dollars, at least at the inception budget, we were transparent about this. You're coming to argue after the fact with a model that was plainly delivered to you upon sale. I mean, how does an association argue that point?
I would say, well, at least prior to this change in the law, which we'll see how it lasts, but prior to the change in the law, I would say you're violating 718. There's only so much you can do in the contract. It doesn't matter if you disclosed it. You're violating the intent and thrust of 718. You've stripped away too much of the rights, which are statutory for unit owners and fundamental to the condominium regime of ownership.
And couldn't I make
for Kyle, chapter 718 is the condominium statute in the state of Florida.
That guides condominiums. That's the regulations around condos.
And I have a question as well.
So couldn't you also make the argument then, David, that if we use Surfside as a little bit of a pivot point in the industry, I should say not a little pivot point, a significant pivot point in the industry as a whole, that boards left to their own devices don't necessarily do as good a job as a commercial parcel owner might do, because they're maintaining it and managing it to a generally speaking, a higher standard, because it's an institutional investment and they have not only a moral obligation, but a financial obligation to maintain their own asset.
Certainly. I mean, I think you see that argument from the developer side, and the other side might say that's the exception to the rule. You had one collapse out of 30,000 condominiums, so we're citing one out of 30,000. But I would agree with you. In working with condominiums, it's difficult to get a group of 3, 5, 7 on the board to do anything. And then once you need the vote of the unit owners for special projects, big projects, that's even more difficult. So yes, there is a problem in condominiums in getting people away from the status quo, getting people away from kicking the can down the road, to take action, to take the financial hit, to think in a long-term range. Because not everyone in a condo is thinking, I'm going to own this for 10 years, 20 years, 30 years, the same way you are with your classic single-family home that people want to live in a long time. A lot of times in condos, people are thinking year to year, just a few years at a time, and that's the problem.
Right? And they also don't have the expertise. In a hotel condo, they don't have the financial or business expertise that a lot of these, management companies and hotel branded businesses have.
Right, Kyle.
When you have a building with these competing interests that creates the tensions that you all been talking about, what is the direct impact, be it negatively or positively, to the residents that's there? What is the impact on them?
It's a great question. So in some of these buildings, it'd say, hey, the commercial component, the hotel component, they're redoing the lobby, which is really the entrance to the hotel and the pool, and they're passing this huge special assessment. And why is the residential component of the building, us 100 unit owners, why are we paying 2/3 of it? How did they come up with that? Well, why do we have to pay so much? What are they paying? What's their share? That's kind of the classic example of what you're seeing.
Or why are you spending money on the lobby that's more for the hotel component than you are in the hallways where we have to walk into our unit? Or why are you spending money on the lobby and not fixing the pool area,
Right.
or you're not fixing the parking deck, or you're taking away the tennis court to build a pickleball? So, there are all these, it's not just competing interests in money. It's also the condo owners, they want what they want. And the hotel people who are running the hotel, they want what's going to make them the most money.
Right.
Yeah, and remember, more and more of these hotels are just trying to keep the guests on property from start of the trip to end of the trip. They're adding restaurants, they're adding cafes, they're adding more bars, you even have nightclubs in these hotels. So, they're trying to capture more of those dollars, which can also be uses that are not consistent with the residential condominium. Noise, traffic,
Right.
jammed up valet. What kind of crowd is coming there now? These are all competing interests.
Riff-raff,
Yep. So I
violence.
think some of the stuff that I see in my work with developers, and it's coincided to my work with condo boards, is having developers come up with reasonable, right, in both the practical and legal sense of the word, reasonable approaches to what expenses get assessed to residents as a function of this hybrid facility. And I'll use the example, building off what David Podein just said, of food and beverage. So when you look at, for instance, a revenue producing department in a hotel, does the commercial parcel owner, developer, hotel brand have the right to assess a resident for some of that expense? And does the resident actually benefit from any of that revenue? Because one could make the case of saying we should proportionately benefit to the proportion of contribution. So if I'm giving half of the bartender's salary out of my maintenance assessment, then I should also get half of what that bartender gets as far as revenue,
or half of the bottle of booze.
It's something.
Something.
But on the flip side, then you can also have a hotel argue to say, yes, but you're not paying for the hourly wage, but you're not paying for the training. You're not paying for the use of our brand, which draws people into this hotel. You're not paying for our ability to purchase things at scale. Condominium associations that try to do food and beverage on their own often fail or often struggle financially because they've got no economies of scope and scale.
Or no software.
All of that. And so I think there is a lot of inherent and possible conflict around this because of this. But then I'd go back to you, David, and ask you, is there a fix to this? I mean, do you see bills like HB 1021 running counter to the rights of residents, or do you feel like there's different areas that we have to regulate and we're going to have to get to those one at a time? Or is this not a legislative issue? Is this more of a functional issue, and buyer beware?
I think I'm generally on the side of freedom to contract. So I generally want to see contracts enforced. I want to see if parties are contracting in a way that's fair and reasonable and actually disclosed and conscionable, that those contracts should be enforced. So I guess the question comes down to, are these shared components, these expenses, is it actually clear? Is it disclosed? Is it clear in the contract? Is it being enforced correctly? I think some of these come down to interpretation. And we all know these condominium documents and related documents, they're very long. Oftentimes you see even the people that draft them, you take their deposition, you ask them, what does this clause mean? David Haber, what do they say sometimes?
I forget.
It says what it says.
Yeah. I mean, so
it says what it says, which is the most difficult. Okay, but what does this mean? Whatever it says.
Right.
I think if we could get it to a place where people know what they're buying into, where the contracts are clear and it's disclosed, then enforce those contracts. But if we're in a position where people don't really know what they're getting into, the contracts aren't clear, and one side is using that ambiguity to their advantage, then I'm not really in favor of that.
Right. Kyle and I had an interesting conversation before the show started about the role and responsibility of realtors and brokers in this whole process. So again, sort of from the everybody perspective, I got to imagine to a degree there's some education that's probably missing on the brokerage side to say when somebody's selling a unit in one of these particular type of assets, where there's hybridization or a shared component or anything else like that, how much burden of responsibility, David, do you believe that somebody who's selling it, whether directly through the developer's office or on a third-party basis, to educate the consumer to say, listen, this is not just a regular condo, and here's some of the things that are going to be of great advantage because listen, you've got all these great bars and restaurants and spas and all this stuff on site, and there's a cost that's associated with that. And by the way, if things go wrong or if things need to be changed, you're also going to bear that burden.
It's a good question, and my answer might be a little bit controversial.
We like controversy.
I think it's unreasonable to put too much burden onto a realtor or a broker. It's one thing if it's an in-house team, directly an agent of a developer selling new condominium and complying with all those disclosures and all of that. But if it's just, I'm a buyer, I have a buyer side realtor, I think it's too difficult to sort of regulate and expect them to vet what I'm buying into, advise me of what I'm buying into, warn me, and comply with a bunch of regulations.
Yeah, and I see it the other way because you're getting paid a ton of money. You can't just close your eyes and say, "Oh, look at the view."
Well, I think
we talked about this in one of the other episodes.
Well, we talked about it with we had an insurance broker, a major insurance broker here in the South Florida space, and to say what role does the real estate, the insurance broker play? Right. They're selling the policy, but they're also being looked at as a subject matter advisor, and to say this is not just about what you're selling; it's also how you're advising.
I think if you're a broker and you know that a building doesn't have reserves and you know they have structural problems, even though you tell the buyer, read the engineering report now. If you know of certain things as a broker, you know that this hotel is a problem hotel and people in the building are talking about the problems or the pitfalls. I think you should be, educating your consumer. On the other hand, as we all know,
he's going to argue against himself. Ready?
Right.
Go.
On the other hand, you get the guy or lady, they walk into the unit, they look at it, it's gorgeous. You don't want to walk away from your commission. So
no, and I would like to see that, and I agree with you. That would be ideal, but I think it's a little more ideal. And I think if you're actually going to regulate it further, is putting more strict and specific burdens on a seller and even on condo associations. I think condo associations, you'll see the disclosure requirements of an association to an incoming purchaser. I think in the future, you'll see additional burdens and compliance requirements placed on the condominium association saying, you association, you have a duty to this incoming purchaser.
Right.
You need to disclose and inform them in something in plain English, in writing, make it available on the web. And you can't just say, oh, it's between the buyer and the seller.
Right.
And you could get our documents or not to review things. I think you're going to see more pressure, more regulation, more requirements on condominium associations, particularly to incoming purchasers.
To be more transparent.
Be more transparent.
And more educated.
If I am a buyer and I'm spending millions of dollars on a high luxury location, should I not expect my agent to be able to tell me everything that I need to know to make that level of purchase? We talk about, the condo association needs to be clear and speak in language, but at that point you have already purchased the property. So my question is,
not necessarily.
It could be disclosure at closing.
Then educate me, because I'm of the example that if I'm buying something,
well, you're a condo owner.
I am, but
sorry,
it's not ultra luxury, but I'm not spending millions of dollars anyway. What should be my expectations? I guess that's my overall question.
Well, I think your expectation is somewhat reasonable. Unfortunately, I don't think the expectation matches up with any of the legal requirements that we're currently dealing with. I think it's reasonable that you would expect, hey, I've hired you to represent me, particularly if it's not just a transaction broker where buyer has their own agent, seller has their own agent. You're thinking, hey, you're my gal. You're my agent in this transaction. And you've done 10 deals in this building. I'm expecting you to know everything about this building for the most part. That's one of the things sort of inherently or implicitly is kind of the agreement between the two people. So I don't think your expectation is misplaced. I just don't think it matches up with the actual legal requirements.
I agree with you that it's going to end up somehow that the condominium association has to deliver not just the condo documents, but the financial statement, how much is in the reserves, and a copy of the most recent engineering report. Yeah. I think that's going to have to ultimately be delivered by the condo association, not necessarily the broker asking for it, but having it not just available, but delivering it as part of the package.
Well,
I think that's going to be the end result.
And now we know, I mean, at least in the case of Miami-Dade County to date, and probably other counties to follow, that there is now a posting requirement that condominium associations actually have to post that for public view through a county website. So you actually can get that even if you're not dealing with a broker. Anybody can log in and get that information. And it leads me to my point that I'm with all of you guys, but I also think, rather than placing the burden of all of this on one particular entity, my guess, David, and I'm interested in what you think, is that everybody is going to have to come to the table and make an effort to clarify, both through the sales process and the governance process, which is to say, the brokers are going to have to do more, the association is going to have to do more, the developer is going to have to do more, that everybody's going to have to play a part in making sure the consumer is educated and protected. So I imagine, and I'll turn it to you, that some of the fallout of an HB 1021 might be less revisiting the substance of it and more expanding on it to say, in addition, a little like 154 did for 4D, let's clarify A, what we mean, and B, some additional provisions that are going to protect everybody.
I totally agree. And I think if you hop in your time traveling machine and you go to a real estate closing in 5 years from now, the documents are going to be 40%, 50% longer. There's more disclosures, more forms required, more parties that are making disclosures and signing forms. It's just going to get more complicated because, if you look at a real estate closing and you see all these documents, or particularly in the residential mortgage lending industry, which is heavily regulated, you see, why is this form? Why is that form?
Yeah, the Reg Z form and this form.
All these forms have come out of laws, regulations, prior lawsuits, compliance, federal law, state law. So I think you're going to see, to your point, potentially be regulated from multiple players, multiple angles in the transaction, which is going to result in more complicated transaction, more forms, more compliance, longer process.
More questions.
Hopefully, more legal fees. Sorry, folks, but I am a lawyer.
That's www.haber.law. Yeah, I'm going to throw one curveball out there as we start to wrap up, which is I want to build yet again on some of this branding conversation and the hotel conversation by saying there is another relatively new entrant to the asset market under condominiums, which is facilities which are truly hybrided and may not actually be a traditionally flagged hotel, but is a branded residence. And there is not a bifurcation physically of hotel units and condo units. There are something called rental management agreements, or RMAs. And so inside of one building, one door on your hallway could be a unit owner. It's a fee simple condo, and it's owned by a unit owner who participates in this rental management agreement, which turns their condo into a hotel room. And the person next door is just a regular owner occupied unit. Yeah. And so then when you get to these issues of financial burden, you're now dealing with, instead of all of the unit owners banding together and saying big bad developer, big bad hotel company, you may have split interests among the residents themselves, because some of them are benefiting from the revenues on these rental management agreements, which are functionally hotels, and some of them are not. And so it sets
pitting one against the other.
It sets yet another stage of this variability, which just seems to be getting more and more complex.
Yeah, I'd agree with that. But I do think those buildings are very interesting because it does solve something in the market where you have people that might want to come to Miami 4 times a year, 5 times a year. They don't want to stay in a hotel every time. It's not the easiest to do VRBO or Airbnb indirectly or behind the scenes or whatever. And so I do think that product is very interesting to people that can say, hey, my grandkids live in Miami. I want to be there 4, 5, 6 times a year. I don't want to pay $800 a night for an okay hotel room, $1,200 a night for a great hotel room. Like, I don't want to pay that. I don't like the product on VRBO and Airbnb. I want to have this asset that I can purchase, but then hopefully monetize for a bit because I'm only coming 4 or 5 times a year. So I do think that's an interesting product, but I agree with you that you're going to have this conflict kind of owner to owner. But from what I've seen is the buildings coming into that space are leaning all the way in, and they're saying like, come buy in this building because you want this flexibility. You want to be in the program. And like, we're not your sleepy, quiet,
right,
everyone lives here 12 months a year. Like right. The whole building is pushed for that. So I'm not sure there's going to be like this mix of people don't know what they're getting into, where they're like so surprised that
it may be even more clear than the other version.
Yeah.
I also think that on those types of transactions and those kinds of units, you have a 30-day maximum stay for the unit owner.
Yeah, it's a great point. A lot
Because
of
if it's a hotel, you can't stay more than 30 days. So
right, because it becomes a residence.
it becomes a residence, and there are different rules for residences than hotels. So if you're coming for up to 30 days at a time, and you can only stay 30 days a year, then you definitely are renting out your unit as a hotel
Right.
for the rest of the year.
Right.
Yeah. I mean, I'm surprised no one has revisited the timeshare model and tried to rebrand it into something new, hip, and more luxurious.
Right.
You know, timeshare has a little bit of a stigma attached to it.
In some cases, I've seen this idea of residence clubs, which is essentially just a smokescreen for that. But it's more the big flags.
Yeah,
that are doing
I'm
that.
surprised Soho House or these other brands, you know, don't have. I can just pay
I get
$1 million.
4 weeks at Soho
Yeah,
House
and
a
I
year
just,
or whatever.
you know, with all these people working from home, all these people not going down the traditional path of I want to have the house and the kids and be in the school district, and you have people that want to have a different lifestyle and have the income. I'm surprised that someone hasn't gone after this market, rebranded timeshares, and say, hey, you can own a unit at Soho House, which we have one in Aspen, we have one in Miami Beach, we have one in New York City, and you get to just rotate around these different cities.
Right.
Don't they have that with Sheridan? Doesn't Sheridan have a product like that?
There's a couple brands.
Wyndham have a
there's a
version
couple.
of
There's a
that.
couple.
But like
a couple
taking it like a step further.
They
and
don't
just
call
saying,
it
like,
timeshare because
yeah,
they want to
and
avoid the association.
And
with
it's not just your vacation residence that you have a certain number of weeks at. You live in the ecosystem,
right.
and you're bopping around to your nice destinations, and you're like, whatever, I just pop in with my suitcase. I don't want to own a bunch of stuff anyways. You know, half these kids, they don't want to own anything anymore. They just want to pop in.
Right. Yeah. And I think it's interesting because there has been a very intentional effort to disassociate with the words timeshare or the words condo hotel because of the negatives of the past. I mean, obviously condo hotel had all kinds of SEC implications in terms of, you know, commitment to returns on those investments. So I know that everyone spent a long time trying to create distance around that. But in effect, this is, if you will, a resurgence of condo hotel. It is a resurgence of timeshare in the residence club capacity. What I think is fascinating to me is, you know, you can look at one of these hybrid types assets and you can see multiple iterations of occupant all at the same time. So you can have the unit owner occupied. You could have a long-term lease. You could have somebody who's actually on leasehold in one of those units. You could have somebody who's in the rental management agreement who's just there for a night through a hotel flag. And you also have, in some of these buildings that also allow other transient rentals, you could have somebody renting with Airbnb or VRBO. All at the same time.
Transient. What a name.
Transient.
What a word.
So it's, you know, you're seeing this aggregation of all these different type of asset use. And it makes me wonder, David, are we going to see in the future buildings that rather than have it be sort of one unit at a time interspersed throughout the building, might we start to see buildings get developed that have a block of hotel units, a block of rental units in more traditional multifamily terms, a block of, you know, unit owner condo use or you know, longer term rental? I mean, it seems like there is efficacy in a model that says it's being asked for and we're going to deliver a turnkey for all of it. And maybe it also makes the sales process easier because you're renting the building long enough and you say, gosh, I love it here, I'm going to buy the condo.
I think so. I mean, if you were to map out types of developments, mixed use, and you go back 30, 40 years, you're not really seeing it. And you see the trend accelerate. And so I don't see that trend going away anytime. I think you're going to get more and more complex buildings where there's this component, there's that component, there's all kinds. I mean, I just saw one. I think there's a proposed project in Brickell where it might even be a limited common element, something that goes along with the unit is like an office suite.
Yep.
Or like a shared or a
that,
private desk or something. So I think you're going to continue to see new iterations on residential real estate development, ownership rights, and use rights, because I don't see the trend reversing anytime soon.
I think you also are going to see, I know in apartments, you're going to see this situation where you only rent one bedroom. You're going to see
already exists, yeah.
Right.
Property Markets Group did that with their X and social brands.
Because they don't. I don't need a whole apartment. I just need one room to sleep in.
Right. Yeah. We've already seen that. So, David, as we wrap up, I think the last question I want to put to you is, and building on what you just said, what is the future here? I mean, are we looking at an even more rapid acceleration into all of this? Are we seeing more branded condos? Are we seeing more hybrids? is the traditional condo starting to be in the rear view mirror, or are we kind of at the height of it right now and we're going to see a return to normal, if you will?
I think the branded condo is going to continue. I think the top of the market is going to continue to perform very well. I think you will see even higher luxury brands get into this space.
Can it get higher?
I truly believe you're going to see, some of the legacy brands eventually get into this space. Your LVMH brands, other European conglomerates. These are very valuable brands that I think some of them will eventually get in. I think you might have one or two that say, we're hoity-toity, we're above that, and we'll never license our name. But I think you'll see
the Haber brand.
The Haber brand.
I'm there for that.
I think you're going to see very high-end brands still come in. The trend to me, like we've talked a lot about risk, we've talked a lot about questions. The trend to me is still long Miami. I think Miami we have so many tailwinds. We've talked about headwinds, but
I like that tailwind.
These are things that will be worked through. These are things we're very much in the weeds. We're in the real estate business. We're in the condominium business. We're really talking inside baseball here. If you zoom out, the trend still is long Miami. If you look at capital flows around the world, you still have a lot of institutional capital that needs to be allocated to real estate. It's not going into office anymore. There's certain cities in America it's not really going to. You don't see as much flowing to Europe. You're seeing it come to America. It's not going into office. So guess where it's going?
Right.
High-end residential.
High-end residential.
And it's going to be not just Miami. It's going to be all the way to...
Shout out to all my industrial clients.
It's also going to go all the way to Palm Beach. It's not just Miami.
It's not just Miami. I'm a huge fan of West Palm. I think in 10, 15 years, people are going to be like, I cannot believe we slept on West Palm. Right. It's gorgeous.
I agree.
It's absolutely gorgeous. You have Palm Beach adjacent to it.
You've got the international airport right to the west.
I
got
think
all kinds of bright line running through it.
Yeah, and it's going to be a no-brainer that with the train to Miami, I think people are going to be like, I can't believe I slept on West Palm.
I can tell you, Stephen Ross and the owner of Citadel, the head of Citadel, they're very big on Palm Beach.
Yep. No, it has been big.
I think the top of the market is going to continue to run extremely well. Of course, there's going to be market cycles, but I do think Miami is special. We're a very diverse place. We have a lot going on in terms of economics, political environment for business. We have people from all around the world that want to be here. They feel safe here. They like what Miami and South Florida is about. So I think we have tremendous tailwinds in the Miami, South Florida real estate scene.
In fact, you can go to a restaurant in Miami, Kyle, and you can hear Portuguese, Spanish, English, French, Creole, Russian for sure,
Boston.
Yeah, that
and
is
what we need.
Hey, buddy, can I park my car in the front there?
No, it's just get me a lobster.
Well, we need to really turbocharge the market. We need to get amazing flights from Asia here, and we need to tap into the Asian market.
I don't disagree with you.
That's absent. Yeah, it is absolutely. David Podein, partner at Haber Law. It's been great to have you here.
I could do this all day. This is real estate is my hobby. I love this.
We will definitely have you back on another episode. In the meantime, David Podein, again, partner at Haber Law. Appreciate your time. Appreciate your perspective on branded residences. Sounds like there's as many questions as there are answers, but your expertise has been invaluable. So thanks for joining us.
Tommy Tower and Haber House.
This is Sunset and Sold.
Yeah, I'm signed up for the Tommy Tower wellness gym.
I love it, and we're going to feature that in my outro here. www.sunsandandsoul.com. Join us on Instagram, on LinkedIn, or on Apple and Spotify. We'll be right back.